On the 28th of May 2023, the Texas legislature approved the Texas Data Privacy and Security Act. The bill is now in its final stage to be reviewed by the Texas governor, who can sign it into law, reject it, or let it automatically become law at the end of the 20-day window without his signature. Should it be signed into law, the bill will be implemented starting July 1st, 2024. So why should we care about this bill? Well, once it becomes law, Texas will join the club as the 10th state to adopt a consumer data privacy law. However, this law stands apart from others with its unique applicability provisions. And with Texas' population inching towards 30 million, this is not something companies can afford to ignore. In particular, it could have huge impacts on companies without proper data subject request processes and data retention schedules. Yes, you heard it right, data retention schedules. Let's start with the applicability first. The Texas bill distinguishes itself from the previous 9 state privacy laws through its unique standards of applicability. Unlike previous state privacy laws where we would have clearly laid out thresholds, the Texas Privacy Bill applies to all persons that are not classified as small businesses as defined by the US Small Business Administration. Of course, regardless of the size, in order to be in scope, the business should process personal data and produce products or services in Texas, or its products or services should be consumed by Texas residents. Regarding what is a small business, the bill says that the standard for small businesses should be followed according to the US Small Business Administration. The SBA's Table of Small Business Size Standards is an official tool available to determine if an entity qualifies as a small business. According to the size standards, a small business is defined primarily by the number of employees or its annual revenue. However, these standards can vary widely depending on the industry. For instance, in some manufacturing industries, a business might be considered small if it has fewer than 500 employees. But in other industries, the threshold might be 1,000 employees, or the business might be considered small if its annual receipts are less than a certain amount, typically measured in millions of dollars. Another interesting factor to keep in mind is that the SBA occasionally updates these standards. So a business that is not subject to the Texas Privacy Bill today could become in scope without growing in size. Additionally, although small businesses have been left out, when it comes to selling sensitive data, even small businesses are required to obtain consent. What are the exceptions to its applicability? At first, similar to many other states, it does not apply to employee data and data collected in the commercial context. As you may already know, so far CCPA is the only state privacy law that doesn't recognize employee and B2B data exceptions. Additionally, the Texas Act does not apply to state government entities, non-profit organizations, companies subject to the Gramm-Leach-Bliley Act, information governed by the Fair Credit Reporting Act, covered entities and protected health information governed by the HIPAA, institutions of higher education, and finally, information governed by the Family Educational Rights and Privacy Act. Now let's address the elephant in the room: the potential impact of this act on your privacy program management and day-to-day activities. I will assume if you are already compliant with one of the other state privacy laws, you should already have the key areas of privacy program management. If you look at the impact of the Texas Privacy Bill through the lens of these areas, the most impacted area will probably be DSAR processes and data mapping. The reason for that is, we are talking about the second biggest populated state in the US. Once the bill becomes law and goes into effect, 30 million new consumers will be granted individual privacy rights. As of right now, only California and Virginia have privacy laws in effect, totaling 47 million data subjects. But once the already enacted privacy laws come into force, the volume of data subjects will increase by 60 million. Not to even mention other state bills that are still in the legislation process. The introduction of new privacy laws generally leads to increased consumer awareness of privacy, potentially leading to more consumer inquiries, requests, or complaints about privacy matters. So you may expect an increase in DSARs to triple or quadruple in the next few years. Moreover, for certain requests, controllers will have to require their processors to take the same actions controllers take. Therefore, this will likely tighten the due diligence on processors. And hear me out, this will force even small businesses to create their data maps to assist their clients when responding to DSARs. Yes, even small businesses that are not subject to the bill will soon start feeling the cold breath of their clients on their necks. And in order to efficiently fulfill the DSAR requests, companies must have a robust data map to ensure they can locate an individual's data in the systems. Accurate data maps will also be crucial to expedite the process of responding to DSARs, which is very important considering the strict time limits. Let's not forget that the law stipulates a civil penalty of up to $7,500 per violation. Finally, more important than ever, organizations should start putting in place the retention policies that have been waiting in the draft for years. This is important to both businesses and service providers. No joke, if you keep a consumer's data for years, you should be ready to explain this to consumer or to your clients on behalf of whom the data is stored. So in summary, with the surge in consumer awareness, expect a boom in DSARs and a critical need for long overdue data retention policies. Meanwhile, stay well and don't forget to subscribe.